Hello, criminal trial process. I am going to record our first video, and I had some technical difficulties. I tried doing the Microsoft PowerPoint uh, video recording within the PowerPoint, and now I can't remove it, and the sound is, you can't hear it. So I cannot play through the slides. I have to just click on them, or else it ends up taking over. Anyway, it ends up taking over the PowerPoint video and it didn't go well. So for this first lecture, it's going to look a little rough. So this first lecture is on a review of the American courts and a review of law. So as I said, I have to just scroll through each video. Let's see here. So the overview, criminal law is sometimes referred to as substantive law. It's the law of crimes. It's defined by state or statute or penal code. The code of conduct is something that our society follows and is expected to follow. A violation is an act against the state as well as the victim. So committing a crime isn't just a crime against a victim, but it's also a crime against the state. The purpose of criminal law is to protect the public from harm and punishing harmful acts. A crime is a violation of a criminal law. Punishment is prescribed. It is set with the statute. A person must have intention without justification or defense. Mala in se crimes are those against that are inherently harmful, and those are crimes against persons. And mala prohibita crimes are those in which there really is no consensus for if it's harmful or not. And that's something that's an example such as possession of marijuana, which is actually illegal in California, as you probably know. 5 elements of criminal liability. The first one is actus reus, a criminal act. It's voluntary, doing something with your body that's voluntary, or an omission of a legal duty to act, or possession. So that's the first element of criminal liability to make up a body of a crime, which is known as corpus delicti. So actus reus is the first one. Second is mens rea, criminal intent. And this is levels of intent. There's varying levels of intent. If we're looking just at murder itself, first degree murder is premeditation, second degree murder, not premeditation, but it is malice. Manslaughter or involuntary manslaughter, you didn't mean to actually kill someone. The third element of criminal liability, concurrence, the combination of the criminal act with the criminal intent. Number 4, causation, 2 types. There's factual and legal. Factual is the defendant caused the harm because of their actions. Legal is, although the defendant may have caused the harm, they may not be legally at fault. And then last is harm, causing an injury to another. So those are the 5 elements of criminal liability. Okay, incomplete crimes. And this is just an overview, just to start off this course. Incomplete crimes, crimes that someone tried to commit, but they weren't successful at it. Those are called inchoate crimes. And an attempt, well, a person might still be prosecuted depending on the attempt of the crime, such as murder, attempted murder. People are prosecuted for that, and there's certain levels of punishment for it. Solicitation, the intent to persuade someone else to commit a crime. Murder is another example. Conspiracy, an agreement between 2 or more people to commit a crime. Murder is also another example for that. Parties of a crime, those who assist in the commission of a crime, or an accomplice, or someone who helped someone else with the commission, such as an accomplice. Each state will vary in statute and punishment on each one of these areas, and they can vary in charges. Defenses to criminal liability, there's the affirmative defense. So the defendant has to prove that they're not responsible for their actions. There's also justification defense, an admission to the act, but it wasn't criminal. A justification might be self-defense. Somebody was defending their own life. A retreat doctrine. Some states require a person to retreat, but some states don't, where you don't have to retreat. You can use deadly force if somebody's attacking you. The castle doctrine is, and most, if not all states have this, where your castle is your home. If someone comes into your home, there is no expectation to retreat. You don't have to run away from your own home. You can protect yourself. You're also allowed to protect your family. RVs and tents, if someone's camping, often is seen as part of the castle. So if you're camping, your RV or your tent might be your castle where you're allowed to protect your own life in that area. Alibi, you're saying I didn't even commit the act because I wasn't there, and I have an alibi to prove that. An affirmative defense, going back to that, is certain things like maybe age. There's a case where a 7-year-old shot his teacher that's going on right now, and he's not being prosecuted. A 7-year-old in that state is being seen as too young to be able to know any better for the action. So that would be an affirmative defense. Insanity is another affirmative defense, which has to be proven if someone's saying I'm insane. Or diminished capacity might just be the mental stability of someone. A quick review of crimes against persons and property crimes. Murder is killing another person that is purposely, knowingly, and recklessly. Homicide is taking the life of another person, but it might be justifiable. So homicide will have homicide investigation. It's not necessarily a crime. It's an investigation to determine what type of crime it is. Murder, you could have first-degree murder. That's premeditation. That's the highest level of murder. Second degree is someone purposely and knowingly and recklessly killed someone, but it wasn't premeditated. Manslaughter is there's voluntary and involuntary. It's not purposeful, but someone is reckless in their actions that ended up with someone else dying, and that might be drunk driving or driving under the influence of marijuana. The person didn't purposely intend to kill someone, but because of their actions, which were reckless, they ended up hitting and killing someone. Felony murder, a person dies in the commission of a violent felony crime. An example might be a clerk is robbed at a store, and perhaps the victim slips and falls. The clerk slips and falls, hits their head, and dies. The people committing the commission of the robbery are now held accountable for felony murder. Even though they didn't want to kill somebody, they just planned on stealing the money by force or fear. If the clerk died, they're now looking at possibly second-degree murder in some states, which is 25 years in California. Rape is another very violent crime. The elements of rape is non-consensual. It could be by force or fear that they're forced into an act, the penetration of the body, and there's different subsections of rape depending on that. Assault with a deadly weapon is usually a felony, and that might be, well, it is a felony, using a weapon to hit somebody, but punching somebody severely, stomping on someone could be assault, and that's typically a felony. Battery, physical contact, but not necessarily an injury, usually is a misdemeanor. Maybe spitting in someone's face or pushing someone, that is typically battery. Robbery is taking property by force or fear. Burglary is entering a dwelling, it could be residential, it could be commercial, with the intent of stealing property or committing a felony. So if someone entered a residence with the intent to, let's say, rape someone, they're also looking at burglary charges. They entered a dwelling with the intent of a felony, they're also looking at burglary. But entering a dwelling with the intent of committing a theft is also burglary. So if it can be proven that somebody entered a commercial business, maybe they didn't force entry, doesn't require forced entry, but they entered and they had the intention of stealing, they're looking at burglary. That's a charge that can be argued. Theft, there's misdemeanor theft, there's felony theft, and it really depends on the value of the object, and that keeps changing in our penal code. Herbert Packer in 1968 came up with the crime control versus due process model of crime. And this is a debatable topic. The crime control model, it views the criminal justice system as sort of an assembly line. The main goal is controlling crime, and it emphasizes in the value of this model efficiency, speed, and finishing up the whole disposition of the case is the goal. The process of adjudication is informal screening by police and prosecutor, and it focuses on factual guilt. It views the apprehension and conviction of criminals as the most important function of the criminal justice system. Now, the other model is the due process model, where it views criminal justice system as an obstacle course, so to speak. The goal is protecting the rights of the defendant, and it emphasizes reliability of facts and evidence. And the process of adjudication is formal. It is adversarial. It is going to court, and those who are accusing you, you're allowed to cross-examine. This focuses on legal guilt, so you have to legally prove that someone committed a crime. The emphasis is placed on fact-finding procedures with the constant scrutiny of the outcomes to ensure mistakes have not been made and defendants are presumed innocent until proven guilty. So this is our current criminal justice system. But there's kind of really a combination of both in our criminal justice system. But looking at these different models can be debated and is a good debate to have, the pros and cons. Civil law, a quick overview of civil law, is non-criminal. It's a dispute. One part is a dispute between private parties. The government may also be involved in some cases. The plaintiff is the person filing a lawsuit. The defendant is the person being sued. Punitive damages or compensation is punishment for actions committed. People aren't going to jail. They're fined money. And voluntary commitment, this is part of civil law, is someone is committed to a mental institution against their will. This is not a suit, but it is someone doesn't want to go. It falls under civil law rather than criminal law. Tort law is there's a breach of individual contracts. Property law has to do with real estate matters. Contract law has to do with business matters. Family law, divorce, child custody, spousal support, dividing property. There's also accident injury law. All of that is civil. A quick overview of our federal, state, and juvenile courts organization and structure. In our federal system, at the top, we have the U.S. Supreme Court, which is the highest court in the land. It is federal, and they look at our federal statutes and U.S. Constitution to see if it's been violated in a case. It is the court of last resort. The U.S. Courts of Appeals are federal courts of appeals. We have 13 of them in the United States. Below that is the U.S. District Courts. These are trial courts for the federal system. There's 94 courts in the United States. There are 677 federal district judges, and they are appointed by the President of the United States. They are appointed for life. We discussed this in criminal evidence in a lot more detail, so I'm not going to dive into it here. And there are also magistrates, which are judicial officers that they conduct preliminary hearings and they issue warrants for the federal system. But our federal judges are the ones who oversee our federal cases for trial. There's also the military court process, and they have their own court system. We also have veteran appeals, federal administration agencies, and boards. Our state court, so we have about 100 million cases are processed in the state and federal courts each year, and 98% of them are in the state court. So it's most of our cases, criminal cases, go to the state court. Starting with the smallest, we're doing the opposite here for state, small claims, city, town courts. They handle misdemeanor and traffic violations and small claims. Our probate courts handle adoption, estate, when someone passes away and they have an estate and it goes to probate. There's miscellaneous criminal and juvenile cases in probate as well. Our circuit court is domestic violence, juvenile, traffic, property, mental health issues. There are some jury trials, but not in small claims. Our superior court is the one that in our criminal justice system we mostly deal with. They handle the violent crimes such as homicide. There are jury trials. There's also preliminary trials at the state Supreme Court, Superior Court rather, I'm sorry. And there's juvenile, there's also traffic, but it's mostly homicide and violent crimes are handled in the Superior Court. Tax court is a different court that has to do with tax appeals. And then our state also has a court of appeals, and that's for criminal and civil appeals in our state system. And then the top is our state Supreme Court, handles felony appeals, handles other types of appeals, and they do handle the death penalty cases, which is you get an automatic appeal for a death penalty case. So most of our violent crimes go to the Superior Court, and then there's the Court of Appeals as well. Juveniles have their own court system. The Juvenile Justice and Delinquency Prevention Act of 2002 stated that juveniles that are not charged with adult crimes shall not be placed in correctional facilities. So if they're not charged with an adult crime, those who are charged with an adult crime, such as a homicide, may not be confined with adult inmates. They may go to an adult prison, but they can't be mixed in with the adult population. Juveniles, when they're first arrested, are not allowed to be detained or confined in an adult jail, and they may be transferred once they turn 18 to an adult prison. They may be intermixed with the population once they turn 18. The juvenile court process, there's intake, there's rehabilitation, probation, community service, and fines. There are detentions for serious offenses, and the juvenile is detained. It is up to the judge to decide if the juvenile should go to adult court. It is up to the judge to decide if the juvenile should get probation, community service, probation, rehabilitation. So juveniles, it's a judge that decides the outcome of the case for juveniles. Now, an important point to mention are certain juvenile detention facilities are being closed down. The juvenile detention facilities in San Francisco are closed. They are not housing juveniles in a juvenile detention facility. They are getting rehabilitation and probation. And if they committed an adult crime, such as murder, then they may be tried as an adult, but not housed with adults. I believe that throughout the state of California, this is happening. So it's starting to happen throughout California where juvenile detention facilities are, I don't know what the timeline is as far as them closing, but we're looking a lot more at rehabilitation and probation for juveniles, except for those with extremely violent crimes. And then they're looking at whether there's a juvenile facility or not, they look at adult sentencing. But juveniles are always kind of handled differently than adults. There's a key case in this. Marbury versus Madison is a very old case, but it established the authority of the Supreme Court. And just in a nutshell, this was 1789. There was the president at the time, Adams, appointed some federal judges right before the next president took over, President Jefferson, which is an opposing political party. And Marbury was supposed to be one of the federal judges, and then he never got sworn in, so to speak. So once the President Jefferson and his administration and cabinet took over, they did not swear in Marbury. So he took it up to the Supreme Court. Basically, the entire case ended up establishing the authority of our United States Supreme Court to oversee the power of judicial decisions and judicial review. So that's the reason why this case you may hear about, Marbury versus Madison. It's not that it's such a big deal that somebody didn't get appointed as a judge. It's because of how it established the U.S. Supreme Court in the authority that it has. And that is the end. So I'm going to stop.